I'm Joe Romano, a member of the Burns-White Workers' Compensation Department. I've been practicing workers' compensation law for about 10 years. I solely represent employers and insurance carriers in workers' compensation claims. Let's start with the current status of litigation in Pennsylvania. As it stands right now, workers' compensation judges are conducting hearings via telephone. This began at the end of March 2020 or in very early April. Recently, there has been a push to begin utilizing more video hearings. The governor has also allowed limited ability to have live hearings when requested. When considering a live hearing, each judge handles those requests differently. There must be a legitimate reason to request a hearing. One consistent is that if it is a SCAR claim in which the SCAR must be viewed by the parties, we will be entitled to a live hearing. For some judges, simply reciting an issue of credibility specific to a particular claim will be sufficient to enable a live hearing. For other judges, they will require a more detailed, specific reason as to why a live hearing is necessary beyond just a credibility concern. In some instances where a video hearing has been requested due to those credibility concerns and any of the individuals involved in the litigation is unable to participate in a video hearing, then the judge may allow a live hearing to occur. With respect to mediations, mediations are being held remotely only. There was a period in July where judges were allowed to attend mediations at particular locations outside of workers' compensation adjudication offices. However, that practice has ended and all mediations are being held remotely. At this point in the litigation, it's necessary to applaud the workers' compensation judges, the Office of Adjudication, and everyone to have allowed our system to continue running pretty efficiently despite all of the COVID-19 precautions that are in place. The system is not perfect, but it has been good enough for now. With that said, my own perception of the system is that I have lost a bit of an ability to perceive the claimant and how they are interacting with me during testimony and during mediations. It's difficult to judge the comfort of an injured worker while I'm questioning them on cross-examination. It's also more difficult to get a feel for the injured worker during negotiations in a mediation. For that reason, especially in mediations, I have adjusted my strategy to take a more cautious approach in handling mediations, and my mediations have actually grown longer due to an inability to really feel out the claimant during that negotiation process. Like I said, the system is working well enough, but there is absolutely no substitute for interacting with the injured worker, their counsel in a live setting, either during testimony or in a mediation. As for the Workers' Compensation Appeal Board, it is for the most part standard practice as it has usually been. Briefs are being filed pursuant to the old deadlines. However, arguments are being held via telephone. I don't believe that there has been any issues in that regard, simply because the oral arguments are usually short in nature to begin with, and I believe those are appropriately being handled via telephone. I think that there is a push in the future for video argument, but for now it is telephone only. As for the future of the litigation, it's tough to tell where we are going. I think for the most part, this will all depend upon just the various factors that we are looking for in our own personal lives to allow more leniency in what we do on a day-to-day basis. There has been no timelines provided from the Office of Adjudication as to when more live hearings may be authorized. So we are playing it by ear for now, and we anticipate that telephone hearings will grow more frequently into video hearings. And then hopefully, as this pandemic continues and more treatment options are available, we will be able to progress to live hearings in 2021.